Hey, Gary Tabakman here, criminal defense lawyer in Houston, Texas. Today I want to talk to you about going to trial in a fraud case, specifically a federal fraud case. Do you want to go to trial? Do you not want to go to trial because you're afraid of the risks? Have you been given a potential plea agreement that you're considering in order to be able to make a decision? Are you sitting down with your family trying to figure out what's right for you, what your future may look like? Well, this video will help you understand the pathway moving forward because it's confusing, it's taxing, and frankly, it's incredibly scary. So where do we start? At first, obviously, we want to be able to look at what your actual charge is. In any fraud case, the guideline manual will ultimately control where you fall on a potential scale for purposes of time that you may do in prison. Most fraud cases typically start at what's called a base level offense in the guidelines. That base level offense is through the U.S. Sentencing Guideline Manual and the 2B 1.1 charting that's inside this manual. Why do we want to look at this? Well, here's the reason. If you set your case for trial and you believe that moving forward to trial is your best way of getting out of trouble, the thing that most individuals do not understand is that after trial, the level of enhancements and the level of punishment range goes up significantly. In my line of work, and most criminal defense lawyers that do federal work call this to be a trial penalty. Is it fair? No. Does it borderline violate your constitutional right to trial, your constitutional right to move forward and cross-examine your accusers? Frankly, yes, I think it does. But this is the lay of the land. This is how things operate in federal court, and we have no choice but to adhere to the concepts and to what we can do in order to get out of that space and to help you make the best possible decision. So how do we make that decision? Well, I want to be able to walk you through that and explain to you through examples of what this may look like. Let's start at a very basic fraud case. That fraud case could be wire fraud, bank fraud, insurance fraud, Medicare fraud. Frankly, it doesn't matter. Fraud is fraud. And how does a government make their fraud case? Well, typically it's through tracing money. And once they come up with a nominal amount, and once they come up with your participation, once they come up with what was used as far as the types of vehicles that were used to move money around, they can come up with ideas of how to enhance you and how to make your case seem much more salacious and much worse than where you actually stood when your case started. At trial, don't forget that the judge who ultimately sentences you gets an opportunity to hear absolutely every aspect of your involvement and how the government portrays your involvement to be. What that means is that the court becomes much more aware of who you are, what your involvement was, and how you participated in the crime. Much more so had you not taken the step moving forward in a trial and you've preserved your freedom by coming to a plea agreement that makes sense for you and that gives you the best chance at the best possible outcome, sometimes even probation. And so how do we get there? Well, at first, I think you need to understand that you have to be able to navigate the sentencing guideline manual with your attorney so that your attorney can explain to you the ramifications of the best and worst possible outcomes in a case. I will give you a very simple example. I had a client charged with Medicare fraud back in 2020. This was prior to the COVID pandemic. The sentencing guideline manual on this case was he was an individual that was a minimal participant who did not participate in the actual scheme of acquiring the funding that ultimately was the massive loss amount. What his participation was to facilitate and to help the doctor that he was working for in order to be able to help that doctor enrich himself. My client didn't do that. And so, of course, my client felt that it was only fair for him to be able to go to trial to prove his innocence, which, as we all know, it is not up to us to prove anybody's innocence. It's up to the government to prove their case beyond a reasonable doubt. But when people such as my client in this scenario are charged, they feel that it's inherently unfair for them to be charged alongside with someone else, such as the doctor that enriched himself in a vastly ranging criminal conspiracy. And so, of course, his intent was, I want to go to trial. As much as I try to explain the ramifications and the risks of going to trial in a situation like this, My client has an absolute constitutional right to go to trial and to testify in trial and to choose whether or not that trial is going to be before a jury or a judge. And so, of course, we proceeded. Now, what was the outcome? Well, the outcome became more dangerous because he was found guilty. And the reason he was found guilty is because for the government to be able to prove up a conspiracy case is not complicated. However, the challenge for him became, as though he was a minimal participant, he was grouped in together with everybody else involved. So even though he was the small fish, he was the only one that went to trial. The court found out a lot more information about him and his potential involvement in the case. And of course, whenever his pre-sentence investigation report was drafted in order to give the court an assessment of where his punishment range should be, it came back with a much larger and much higher number than we were at whenever we were considering a plea agreement. So his base level offense started at 6. And typically what happens in 2B 1.1 is you start either at 6 or a 7. We then start to look at loss amounts. Those loss amounts are fairly complex because we have to figure out which number the government is actually looking at or the PSR writer was looking at. And this is where some of the contention may come in as far as being able to object to the PSR. However, what a lot of people don't understand is that you may have been the smallest fish on the block. You may have contributed to the smallest amount that somebody may have defrauded from the government, but you're going to be exposed to all the relevant conduct of the entire conspiracy. So in this case, where the doctor in my client's case made off with $3.5 million and fled the country, was never arrested, my client, who made almost no money, had to bear the brunt of the loss of the $3.5 million in the greater scheme of the entire conspiracy. It's not fair. But the reason that happened is because he chose to go to trial. So what happens when the loss amount is that high? Well, the guideline manual under 2B 1.1 B1 tells us specifically how many points are added for a loss amount in a federal case. So the biggest driver of a fraud sentence is automatically going to be that point count. Just as an example, anything above $6,500 adds 2 points. Anything more than $15,000 adds 4 points. More than $550,000 adds 14 points, so on and so forth. So in this particular case, loss of between $3.5 and $9.5 million is an 18-level enhancement on top of the 6 levels that we start at. So that situation automatically puts an individual like that, such as my clients, at a level 24. And we could talk about how the point breakdown operates in just a little bit, but the important part of that is that it doesn't end there. And so what a lot of people don't understand is, well, what else happens within that scope? What the guideline manual has in its arsenal are enhancements that ultimately increase the possible sentence of a person's prison time based on their actions, what they did, how many victims were there, what was ultimately done by the individual in order to perfect the crime. So in this particular situation, whenever we started looking at it, we got an enhancement that was another 2 levels because there were more than 10 victims. We had another 2-point enhancement that involved a government health care program. We got another 2 enhancements for what's called sophisticated means, where someone engaged in conduct that constituted sophisticated means. And the definition of all of these things is, of course, in the guideline manual, and I'm more than happy to explain to you what those actually mean. But as you could tell, it gets worse and worse and worse. In addition to that, because somebody's identity was used fraudulently in this case multiple times, he also got hit with a 2-point enhancement for an unauthorized transfer or use of identification. Then there was another victim-related adjustment in this case, because any time that there's a kickback network that is being used in order to pay out Medicaid amounts, there is another 2-point enhancement on that. Then he had another 2-point enhancement for certain types of vulnerable victims in the community. Another 2-point enhancement for now role in offense, where his role in offense initially started as somewhere as a minimal participant. Because of the testimony that was elicited by the government, there was more information that came out about potentially what he may have been doing, how he may have been doing it. And because the other individuals did not go to trial and cooperated with the government and came in to testify against them in order to be able to get a benefit in their sentencing, he was the one that ended up getting the worst possible guideline adjustment manual. So he received another 2 points for the adjustment of the role in his offense, which took him from a minimal participant to a more than average participant. Now, then there was another adjustment for what's called abusive position of trust. So anybody that has access to Medicare, Medicaid numbers that can facilitate, for example, the actual cause of drafting out money from the federal government by applying those Medicaid numbers, that is a position of trust that an individual has. Because he had access to this, they also hit him with these 2 points. So let's just take a look at all of these numbers and I'll explain to you where we ultimately ended up. Because this individual decided to go to trial as opposed to the plea agreement that we had on the table, which would have very likely capped his entire sentence to about a point level of 18 to 24 months, which would have been at a level 15 when we were talking about the plea agreement. This individual decided to go to trial and his offense level shot up to a level 40, which was 292 to 365 months. So as you could tell, we had an individual that was potentially looking at a 24-month sentence, which is about obviously 2 years, to someone that was going to be looking at about 295 months, which is well over a 15-year sentence, much higher than a 15-year sentence. And so the disparity is significant. So what decision-making ability did this individual make in order to get him there, even though I've explained all of the risks? Why did he ultimately end up doing this? Well, look, at the end of the day, a lot of it has to do with pride. Some of it has to do with ego. Some of it has to do with just you not being able to come to a decision that makes you feel like I'm being torn apart by the federal government. It's not fair. And I'm not taking the bullet because all of these other individuals are far more responsible than I am. And I don't understand why I have to put myself in this position or why I'm being forced to put myself into this position. It's not fair to me. We respect that. But my job as your lawyer and my job as an advisor to other individuals or a counselor to other individuals that are going through these things that pay me to consult on these types of situations sometimes is that you have to make the decision that is not selfish to you. If you have people in your lives, such as family members and individuals that care about you, you need to make the smart decision that ultimately gets you out of this space and puts you on a pathway and a track of success and getting out of prison sooner, potentially maybe even avoiding prison altogether. So the risks and the driving factors are really significant. Now, is all lost because this individual went to trial and he tested the system and he used his constitutional right to be able to test the system? No, he did not get the sentence at a level 40. Ultimately, we went to sentencing and we did have an opportunity to argue our position to the court as to what we believed the appropriate outcome was. And ultimately, his sentence, although it was higher than the level 15 where we started at, he ended up with a much more reasonable outcome than the level 40 that the PSR writer had compiled. But the reason I tell you this is because this happens all the time, especially in fraud cases. A lot of people do not understand the amount of enhancements that are inside this book and how they operate and how they can apply to your case. And in this individual situation, we got a total of 10 points of enhancements that went on top of just the loss amount, and he did not get a 3-level downward departure for acceptance of responsibility and not needing the government to get ready for trial. So giving the government the ability to not spend their time going to trial. And so you have to make this decision wisely. So I suggest that if you find yourself in this kind of space, if you're facing the type of prison time that we just discussed, or even a smaller amount potentially on the guideline range, consult with someone that understands the inside out of this manual, how it works, how it will impact your case, how it will impact sentencing before the judge that you were before, because that's ultimately going to also make the biggest difference maker. Talk to somebody that understands all of these dynamics, how they operate, and you should be able to have enough knowledge going into this process and be able to decipher exactly what it is that's best for you. And without that, you're not making the best decision for you and your family. If you want to talk to me about your case, I can schedule a free consultation. Click on the link below. I'll see you in the next video. Thanks.